Ladies and gentlemen, good afternoon. My name is Bob Clifford. I'm the senior partner at Clifford Law Offices here in Chicago. Good afternoon to our at DePaul University live audience and also to the nearly 3,800 people who are online right now. We just went over the 3,900 mark of participants and very grateful for that. This is a program that I started 9 years ago. In fact, Professor Robert Burns to my far left is I think the first repeat. He was involved in our very first ethics seminar back when we kicked it off at the office, and we moved it over to DePaul and then expanded it to the internet as it has. So, but permit me to introduce to you Professor Robert Burns, who's a professor of law at Northwestern University. He teaches evidence and professional responsibility. He also is an outside consultant to law firms and parties on matters of evidence, appellate advocacy, and the ethics of the practice. So, Professor, thank you for being here with us today. His full bio is in the materials, and you know, I think it's noteworthy that he received his. He's a doctor. He's a double doctor, I suppose, because he received a JD in 1974 and then his PhD with honors from the University of Chicago with a concentration in the philosophy of law and in logic. That's pretty cool. Like that. Thank you, sir. Welcome. Next to Professor Burns, we have a dear friend of mine and of the organized bar, Mary Robinson. Mary, as all of you probably know, for a time ran the Attorney Registration and Disciplinary Commission here in Illinois. She's the principal of Robinson Law Group, where she provides representation, defense, counsel, advice to lawyers on ethics and matters of professional responsibility. Mary's someone that I know. If we have an ethics issue in the office, we pick up the phone and we consult with her about it. And increasingly, that's something that many of us do, and she's there as a guardian to tell you how to do it the right way. And so, Mary, we're thankful for you being here today. Her full bio, again, in the materials. And then finally, the Honorable John Griffin from the Circuit Court of Cook County. Judge Griffin is a longtime friend. I had the privilege of attending law school with John, and his hair was darker and I had more of it, but that's just kind of how it goes at the time when we first met. There we go. But Judge Griffin sits currently in the Circuit Court in the Chancery Division. He's not only a fine jurist, he's been in the trenches just like all of you as a practitioner for a good part of his career, and he's one of those fellows that in the true tradition of many judges here in America, went from a successful practice to serving the profession as a distinguished member of the judiciary. So, Judge Griffin, thank you for being with us today. As all of you may recall, we start with our hypotheticals. We work through those. I'll ask a variety of questions, but also the team will volunteer as they go along. Our first hypothetical in your materials, and it's on the screen here displayed. You are representing the plaintiff in a product liability action against the manufacturer of scaffolding on which the plaintiff was injured when it collapsed. You have just completed voir dire examination and are going down in the elevator in the courthouse to get a little lunch. And in front of the elevator, you see one of the jurors who has just been selected. Common thing can occur readily over at the Daly Center. Or he tells one of the other jurors, you overhear their conversation. Quote, "I really want to serve on this jury. No way in hell was I going to tell the judge about my own workplace injury when he asked us whether any of us had been injured on the job. The companies that make this shoddy stuff should pay big time." What are your obligations? Professor Burns, what do you think?
Well, you start with the question of, is this a privileged conversation? And of course it's not, because the conversation is between, if it's a conversation, between the jurors, and neither of them is your client. And the next question is it confidential? And of course, the definition of what's confidential is enormously broad under the rules. So if it's a matter that relates to the representation, and this certainly does, then it's confidential. And you cannot voluntarily reveal it absent a specific rule that allows you to reveal this confidential information. So big divide between privileged information and confidential information. And it seems to me that there is such a rule. If you look at Rule 3.3 B and C, you'll see that that rule provides that a lawyer who represents a client in an adjudicative proceeding, that's what you're doing, and who knows that a person intends to engage in, is engaging in, or has engaged in criminal or fraudulent conduct. So the conduct of the response of the juror to the judge under oath was false, and probably both fraudulent and criminal. And it certainly relates to the proceeding, shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. And then Section C says the duties cited in the first paragraph and then this second paragraph continue to the conclusion of the proceedings and apply even if compliance requires disclosure of information otherwise protected, which this is because it's confidential information. So it seems to me that 3.3b requires you to tell the trial judge about what you have heard, the conversation that you heard in the elevator. I don't know of any other remedial action that would be effective under those circumstances. So it seems to me you've got a confidence, and then you've got another rule that trumps the confidence. You've got to come forward.
But don't we have a situation, too, where the lawyer just became privy to admission of perjury before the court by a witness, because the juror is a witness, they swear him in. Judge Griffin, what would you do about that when you found out about it?
Well, I would probably call the juror in, and within the presence of the attorneys, question the juror about what was said, because, you know, we assume they were serious, and we assume that maybe they were just kidding around, but I assume it would be serious. I would question them. You just touched on something, though, that I did want to mention. Before the jury, I'm sure you're all aware of this, but before the entire veneer is questioned, they're sworn in. And they're sworn to truthfully answer all of the questions asked by the court and counsel concerning your qualifications to sit as a juror in this case. So they're under oath. So if that's an admission that they breached that oath. In addition, prior to the jury sitting, we would always give them cautionary instruction 101. And cautionary instruction 101 talks about resolving the case by determining the facts on the evidence, and it talks about you're under oath. You should not be discussing the case. I mean, just discussing the case is violating an instruction that the court has given to the juror. And we warn them, if you violate these instructions, you could be held in contempt of court. To answer your question, that is one of the things that could be done. But another thing that we, as part of cautionary instruction 101, that we tell them is, if you become aware of any violation of these instructions, it's your legal duty to report this to me immediately. Now, I don't see why that wouldn't apply to the attorneys as much as it would apply to the fellow jurors. So, as far as the hypothetical, I think the attorney is absolutely bound to disclose it to the court. I would have the juror in. I would subject the juror to questioning, probably my own, as opposed to allowing the attorneys to question. But usually what I do is I bring the attorneys in chambers. I consult with them. You know, how do you want to approach this? And after consulting with them, maybe they say, I want to ask some follow-up questions. But usually I say, no, I'm just going to question a juror. Then I would question the juror in their presence. I would make a determination. I would possibly excuse the juror. And then as far as sanctioning them, I guess it would depend on exactly what they said. they're probably going to have some.
Judge, can I twist this a little bit, because this has come up in some cases. I'm just curious how you might handle it. Let's assume, for the sake of conversation, that the lawyer doesn't say anything to the court, and then the case goes to trial and goes to verdict. Now, an unhappy litigant makes further inquiry into the veracity of the answers that the jurors gave, and in this instance, one of the lawyers discovers that this particular juror had been injured a couple times and answered, therefore, untruthfully, and now the lawyers come in before you on a motion to set aside the verdict or to impeach the verdict. Have you had that, and how have you dealt with it?
I have not had that. Obviously, they'd be bringing a motion, there'd be a response and a reply. I think that I would evaluate the severity of the non-disclosure fraudulent statement of the juror. I would evaluate that in the context of the fact that it's one juror out of 12, and if it's something that maybe they had an injury they didn't disclose, but did it turn out to be? How important did it turn out to be to the deliberations of the jurors? If we could determine that, and so some of it would be just factually based. My overriding inclination, though, would be to I'd be considering it in conjunction with a bigger motion, almost undoubtedly, of remitter or for a new trial or a judgment notwithstanding the verdict. The standard of that is very high. So my inclination generally would be to let the jury's verdict stand, but it'd be very fact intensive.
The question here from Angela who asked, how likely is it that this juror would be prosecuted in any criminal way?
That gets to the next step, and criminal contempt is a different level of contempt. They have different rights. I possibly would notify the state's attorney's office, and then they would maybe perhaps make the decision as to whether they prosecute. I'm not real high on putting people in jail who are serving as jurors, even if they do something wrong. But this is very, very serious. This goes right to the core of our jury justice system. If we have jurors that are ignoring their oath and bringing preconceptions, biases, hiding them. So, it might be something that I might look at very seriously. But for criminal contempt, there's a lot of due process requirements.
Okay, so let's continue, and I'll get time for one question from the audience.
If there is a possibility of criminal contempt in a prosecution, would you pay any attention to Miranda rights when you were going through your investigation with them?
So the question from the floor, if there is a potential for criminal prosecution and the judge was making this inquiry, would he deal with the Miranda rights issues that might be applicable?
Certainly, if I thought of that.
The question is, would his chambers be considered incarceration, or what do we call that, in custodial interrogation? And I suppose somebody could say that you're putting somebody through a custodial.
Well, let me get a little bit more complicated, and we'll turn to number 2. And it's related, though. We'll come back to any other questions.
Well, I do have one from Stacy who says she doesn't understand why the juror's statements are confidential if they occurred in public and the juror is not a client. Why is that confidential?
Yeah, confidentiality is a very broad obligation. It applies to a lawyer. If you have a current client, any matter that relates to the representation of that client, the duty of confidentiality, which is 1.6, provides that you may not reveal that information voluntarily, even if it was learned
Professor,
in a public spot.
I actually raised an eyebrow about that one, and so thank you for the question, because you're overhearing a conversation, a remark. There's no reasonable expectation in my mind of any privacy associated with that. I don't have a relationship with this person other than the fact that they're another citizen in the hallway of the Daily Center.
Right, and Patrick's asking, isn't it
Mary,
just hearsay?
Mary wants input.
I want to chime in. I had a very embarrassing moment shortly after I joined the ARDC because I really hadn't studied ethics before I got there. The class didn't exist when I went to law school. And I was insisting in a way that was really brain dead, that privilege was what we had to be concerned about. And I had to learn what the professor's trying to explain to us now. Under Rule 1.6, we as lawyers, we're not talking about confidentiality that is owed to those speakers. But we as lawyers, anything we learn in the context of a representation is considered confidential. We can share it to the extent it's necessary to conduct the representation, because obviously you have to be able to say some things about what you learned in order to properly represent your client. But you wouldn't need to disclose this in order to properly represent your client, and in fact, you're really going to maybe do something to the detriment of your client. So under Rule 1.6, you have to have some other reason for revealing that this happened.
So of all the people in the world who can reveal this, the lawyer is the one person who may not pass that on voluntarily.
Well, then we're going to come back to this issue and discussion about confidentiality when we get to some of the later hypotheticals where pretrial publicity is an issue.
We do have one other question there that Al is asking about. What about the second juror, and how would you handle that person in terms of the questioning who was involved in this conversation?
It looks like it's innocent as far as I can tell, the second juror.
But I probably would talk to them again in camera to see what effect that conversation had on them. So I probably would want to make sure that they were not somehow tainted by it. But they'd be innocent. I agree with the professor.
So I think that lawyer in the first hypo must be this fellow in the second hypo, Peter Overton, because it sounds like Peter's a little sketchy. So in hypo number 2, you are preparing your opening statement for the plaintiff in the personal injury action described in hypothetical 1. You are an associate working as the second chair under the supervision of a partner at your firm, Peter Overton. One of the defense's most important witnesses, Sam Green, has a conviction for real estate fraud that was entered 11 years ago. His probation ended 8 years ago. And although the issue hasn't been decided in Illinois, the weight of authority in the federal courts is that probation is not considered, quote, confinement, end quote, under Illinois Rule 609. The partner on this case, Overton, tells you as the associate, I want you to mention Green's conviction in the opening statement. We have a good faith basis that we can admit it. If we can't mention it, mentioning it will just be considered harmless error. That Judge Griffin will view it as harmless error. But it will have an effect on the jury anyway. I don't want to ask for a pretrial ruling on this matter because the more time the judge has to think about it, the worse it looks for us. So Chuck Haskins here, young Chuck Haskins, should you follow Peter Overton's advice? I don't know. What do you think there, Mary Robinson?
I think you could follow Peter Overton's advice. Yes, I do. And I'm going to explain that there are a lot of different ways to look at things. I looked at it when I was the administrator at the ARDC. I wanted to make sure I was right before I said somebody had violated a rule. All right, so I'm looking at it in the light most favorable to the lawyer trying to make a decision. If, and I don't know if this is true, but I'm going to take on this hypothetical, I will conclude that it is not frivolous to believe that you have a good faith basis for believing that you can seek admission of this conviction. Let's just change the facts. You know, the conviction is clearly the person left prison more than 10 years ago. Okay, my answer would be very different then. But to the extent that the hypothetical gives us some clue that there's a basis, a non-frivolous basis for taking the position that the conviction is admissible, there's no rule that says that here's what the rule says. It would be, and I don't know if we put this in there, 3.4C.
We have it, yes. And folks, in your program materials at the end, all these rules that we're citing today are copied there for you at the end of the materials.
But it's misconduct to allude to a matter that will not be supported by admissible evidence. Well, do you know that before you go into the opening statement? All right? No, you don't know that it would not be admissible.
Well, Judge Griffin has a view
Well,
about
wait,
that.
let me finish, okay? Because what I'm telling you is whether or not a lawyer who did this might be subjected to discipline, okay? That's one question. There's a much bigger question about whether it makes sense, whether it's a good idea, and I think that that's what we want Judge Griffin to tell us about.
Okay, Your Honor.
Well, you know, when I read this hypothetical, which I had nothing to do with creating these, and I think they're terrific, the people who did create them, and I really want to commend them. I thought, boy, that's kind of a weird rule, so I went and I read the rules of evidence on this 10-year thing. This book, which is by Justice DeVito, Bob here, he was really excited when this came out, because, you know, the rules of evidence just were codified in, 2011. And Bob thought this was a coloring book for evidence, and he was thrilled. But it turns out it's a color-coded guide that shows the federal rules and the state rules. So I looked it up in here, and actually, in here, in the comments on this rule, it says, People versus Sanchez. This type of time, probation, parole, there's another word they have now, is not counted. So the partner was wrong. I guess what my question is, as a subordinate, what level of, now, and that took about 30 seconds of research. I'm not talking about intense research. But what kind of research should a subordinate do, or do they just, because they work for the person, accept their...
Right. Well, there's a rule, 5.3, is that up there?
5.2b.
5.2b, thank you. That tells us that a subordinate attorney is not going to be liable for taking action that at the direction of a superior if we have a reasonable resolution of an arguable question. So you take your standard, and I agree with you. I thought that the rule was pretty clear. The evidence rule was pretty clear that this wasn't admissible. If that's true, that's not an arguable question. And it doesn't say arguable in the mind of the superior. It doesn't say arguable in the mind of the subordinate. It's arguable in an objective way. So I would say that you cannot just take your boss's word. I'm working on a case that right now is getting a youngster in a lot of trouble. And she did it having gone to a supervisor, told her very definitively what to do. And I think it was terrible advice, okay? And I think she might end up with some serious trouble out of it. So it's an objective standard. And yes, the subordinate lawyer has independent responsibility for checking it out.
So there's no Nuremberg defense. I was just following orders. Of course, it didn't work at Nuremberg either. And
why do we call it that?
Yeah. So there is the leading case on this involves a former judge who became a partner in a law firm, and he walked into his young associate's office and said, I think you really ought to go out there and interview the jurors whom we picked, and find out what they're thinking about this case. And the associate said, "Can we do that?" And the judge said, "Yeah, sure." And so the associate didn't check the rule and said, well, he should know, he's the former judge, and went out and interviewed jurors who had been selected in the case, clear violation of the rule. And the judge was suspended from the practice of the law, and the associate received a written reprimand. So they recognized that his culpability was lower, but he was still culpable, even though he was directed by a former judge.
There you go. Well, Chuck, if you follow this advice, you get to keep that license. So just,
Stu's asking here online, though, that wouldn't the better procedure be to ask for a pretrial motion to allow it in, instead of just saying it? On convictions that are,
Yeah.
10 years old or older.
It's better if what you want to do is get a good, clear resolution. But Mr. Overton wanted not to get a resolution, you know what I mean? But obviously, yes, that would be a more professional approach.
So, Judge, do you allow, I mean, that's fundamentally an advisory opinion, asking for an advisory opinion, right? So if I am on the fence about whether something's admissible or not, in your experience, what's the best pretrial practice? File a motion to eliminate, keep it out, or file for literally an advisory ruling, a declaration, what?
My experience is they've always come in the form of a motion to eliminate. So it's always the other side saying keep it out. Now in this hypothetical, I don't know if the other side, well, they would be aware of it, I would think, and they would have a motion to eliminate.
Right.
That would be the normal way that it's presented to the court.
Okay. All right, let's move on to hypothetical number 3. One of the witnesses whom you intend to call is a co-worker of your client. He will testify that your client carefully assembled the scaffolding on the day it collapsed and diligently followed the directions that the manufacturer provided on laminated cards. He says with apparent sincerity that he explicitly remembers your client wearing his reading glasses while he did that. Your client, however, tells you that his coworker is just wrong about the glasses. He left them at home. He had a hard time reading the instructions on the card, although he still thinks he assembled the scaffolding correctly. May you call the co-worker to testify to his recollection of the event, specifically that your client was wearing his glasses at the time that's relevant to this occurrence. Mary, what do you think?
I think you don't know the witness's testimony to be false. The rule precludes us from presenting evidence that we know to be false. I think that you're going to have a major headache if you go in with that witness saying something and then your own witness, your own client has to say something else. Because then what you're going to have to do, you cannot present your client to testify to something that your client has told you isn't true. So I strategically, I mean, I could say if you isolate just this one witness, you could present that witness because you really yourself don't know what the truth is. But I don't know how you would manage to do that. You certainly can't present both witnesses to say the same thing because one of them tells you it's A and the other one tells you it's B.
Judge?
Well, I have two. At what point would you be talking to your client about and to the witness to reconcile this? Would you talk to both of them and ask them, how do you reconcile this?
I think that's a very good idea. One of the things I was just trying to explain to somebody younger than me, which is everybody these days, when I have learned to let my clients, to avoid having some of my clients dig into a story before I know more. Okay? Not because they're going to, I don't think my clients try to lie to me. I mean, most of them are, I really don't think that they are. But sometimes they talk themselves into something. And then once they've talked themselves into it and they've told me that, they won't come off of it because they're embarrassed. Do you know what I mean? And I guess what I'm saying is it sounds very mushy, but I have a different idea of what's true these days than I did 40 years ago.
I think concretely...
Is that like a Clintonism?
Yeah, it's what is. No, it really isn't. I think what happens is you play in these fields long enough and you realize life is complicated and people really do see things differently. And if you live long enough, you've seen something differently, drastically differently.
Yeah, this issue will come back in a couple of the other hypotheticals. When does a lawyer know that something is false or know that something is not false? I mean, what this issue raises is one of the most thorny issues in professional responsibility and litigation. That's in witness preparation. How do you reconcile? You certainly don't want to present both of these witnesses saying contradictory things. How do you go about attempting to have a coherent presentation of the case without basically counseling someone to testify falsely? Each witness is going to have to be true to his own recollection ultimately, but you have an obligation to test the recollection of either or both of these witnesses so as to get a single story if you can.
Judge?
The comments under Rule 3.3 at one point says, if only a portion of a witness's testimony will be false, the lawyer may call the witness to testify, but may not elicit or otherwise permit the witness to present the testimony that the lawyer knows is false. Now, according to this hypothetical, this witness could also testify that the client carefully assembled the scaffolding on the day it collapsed and diligently followed the directions. Although I don't know how he'd follow them when he couldn't read them, but that's a different story. But I mean, so could you not just say, I'm not asking you about the glasses, you guys don't agree on it.
So what happens, though, to the lawyer, though, who does that? He finesses it. And then the other side brings out and on cross now and says, and he had his glasses on, didn't he? And the witness says, yes, he did. And now you're sitting there knowing better. What's your job then? You have to call for a sidebar and say, Your Honor, we got an issue here?
It depends on whether or not you accept Mary Robinson's very generous notion of what you know and what you don't know. If you know that a witness you called has testified falsely on cross, you're in the same spot we'll look at later where your witness has testified falsely in a situation where you know it's false. So it all turns on whether you know it's false.
Go ahead.
Is there a difference between it being a false testimony and mistaken testimony? I mean, the guy might think, I mean, that's his memory, and that's the deal. He's under oath.
When I was a young lawyer, one of the first cases I tried, I prepped my client on the photos that were in the file, what color was the light? And he said the light was green. So then the other defendant testified the light was red. And so both of us subpoenaed the fellow from Park Ridge for the traffic light controls. And he called me up and he said, I don't know why either one of you guys want me to come in, because at the time of the occurrence, there were no traffic lights at this intersection.
We do have a question here from Barry, who, following up with what the judge just said, that maybe the client could have been incorrect, but why can't you just stay away from that topic when you put your client on?
That's what Judge Griffin advised. That's the finesse. Okay.
Bob, can I ask
Sure.
the professor, there's this line here in the comment to Rule 3.3, and I think it's 8 in comment 8, and it says a lawyer's knowledge that evidence is false. Oh wait, no. A lawyer's reasonable belief that evidence is false. Oh, I'm sorry. I found this a minute ago, now I can't find it. Okay. Second sentence in comment 8. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. What does that mean?
Well, it draws a very refined distinction, let's call it, between what you know and what you reasonably believe.
Oh, okay.
So you can say, I believe that this is false, and my belief is reasonable, but I don't quite yet can't say that I know that it's false. And so if I believe it's false but don't know it's false, this comment says I may present it.
Okay. I thought maybe that's what it meant. Okay.
All right. Well, enough of Mr. Overton and his tales of woe. Let's turn to a new fellow who's got a problem with a residential burglary case. Hypothetical number 4. You represent Peter Jennings in a residential burglary case. Jennings has been convicted at a trial in which he did not testify. The sentencing hearing has arrived, and the judge looks up at you and the prosecutor and says, well, since the defendant does not have so much as an arrest in his record, I am inclined to grant probation. Anything else, counsel? Prosecutor takes a look at his notes and says nothing. You know, however, that Jennings has 2 arrests for possession of a controlled substance with intent to distribute. What, if anything, should you say to the court to disabuse it of the error in the history of your client? Do you have a duty? Wow. What do you think of that one there, Professor? You're laughing.
Well, I mean, again, we have this is not only confidential information; it's probably privileged as well, right? You've learned
about
public
record. Wait a minute, that's a public record.
But you've learned about it from your client, so it doesn't say whether you've checked a public record, but the source of your information is the client telling you that he has this background. So I would say you start by saying, this is confidential information. I may not voluntarily reveal it. And so the question again is there a rule that trumps the general duty of confidentiality? 3.3a provides that a lawyer shall not knowingly fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. That doesn't apply, because he's not the reason why the judge has this false belief. So there is no rule that basically says what would otherwise be confidential, that I can see obviously, it requires the revelation of that confidence. So the question there now becomes, does his silence in the face of this anything else amount to, should it be construed as an affirmance of what the judge has just been said, or will an angry judge someday draw that conclusion? Your silence basically said that's right. That's the issue.
You know, one of the notes I made to myself in looking at this one, or two. One was, you know, credibility. It's so important in the courthouse, and I've always taught the young lawyers, you know, once you lose it, it's lost. How would you like it? Judge Griffin does this. He gives my guy probation, and then it comes out that this record was as described, and the judge comes to me. You remember that? You know, that case of Jennings? Your guy's out today. He should be in the slammer. If I had known, if you'd been honest enough to tell me the truth.
Why wouldn't you say, where was the prosecutor?
I'm not talking about what the prosecutor's job is. I'm talking about what my job is.
We have an adversary system, and who is in charge of putting out the evidence against the defendant? It is the prosecutor. The prosecutor has access to the records. I mean, I'm also going to be strident on this. I don't think arrests are that, you know, this isn't like convictions.
Right. Okay,
so it's probably, I'm not so sure how material it is that the judge thinks that there are no arrests. I mean, that may not matter. But I also think that there is no affirmative obligation under the rules that would require a lawyer to volunteer this, and I'm a believer.
Okay, first a comment by Judge Griffin, and then a question from the back row. Judge?
I know very little about criminal law, but this right to remain silent and not to incriminate yourself, does it extend to something like this? Why would you be like raising your hand and saying, yeah, but I really did more?
Question in the back row? Yes, ma'am.
Sometimes bare arrests without convictions can be expunged. And I know that in our community, there are people always trying to expunge those things. So it may be that those arrests are no longer on the record.
Right from the higher court.
They could very well have been expunged, which is a very vigorous practice these days.
There we go. We got a question in the back row there again.
That is exactly what I was going to point out. The hypothetical did not tell us what the reason was for the arrest not appearing in the record. Yeah. And if, in fact, the arrest was expunged for some reason, that's why they expunged, so that it won't be brought up later on.
I should mention something for the record if it's not so obvious. And that, number one, I want to thank Professor Burns and also Mary for developing these hypotheticals that we're working with today, and then with Judge Griffin overseeing them. But also, you know, there are things that are deliberately not the whole thing in order to spawn this kind of discussion and have these different, you know, nuances talked about as part of the Socratic process here. Okay.
Right. We have people on the internet saying that as well. That convictions arrests are not the same as convictions, and therefore to be considered an aggravation.
Okay.
Can I ask my fellow panelists, and of course Bob, the question? What if a lawyer were to say, in wanting to be real ethical, something like, well, Your Honor, I hope you do not construe my silence as an agreement with what you've just said. Would you be protecting your credibility, surely?
Yeah, I think.
But would that be going too far?
Well, my immediate reaction is that if I was the judge, I think I'd say, what do you know that I don't know? And then now, does that jam you up with your client?
Yes, it would. Now you have to decide whether it's privileged or not, or whether you're impliedly authorized to reveal that, because now the judge is really going to check.
But doesn't the duty, on a serious note, doesn't the duty of candor come in here too? I didn't hear you talking about that, Professor.
There's a general duty of candor, but it does not trump a specific confidentiality or privilege obligation, absent a specific rule that says you're entitled to reveal otherwise confidential information. Now, in the real world, we have arguments about this in the clinic at Northwestern, and people are concerned about whether you're really doing your client a favor by keeping silent, whether it's going to come out anyway, whether in the real world you should come right up to the line here and not at least consult with your client about whether you should tell the judge about this, because it could hurt him in the longer run.
Yeah.
It's possible. Can I just say this? I don't agree with you that it matters whether this is confidential. I think that the rules require us to correct false statements. They require us to correct false evidence if we've presented it, okay? And they require us to tell the judge about controlling authority.
Right.
That we're aware of.
And this is none of those.
It's none of those. And I'm going to be sarcastic.
Okay.
There's no rule that says that you have to help a judge be smarter.
Okay.
There should be.
All right, moving on.
We have a question actually here.
One more question, that's it.
About Rule 3.3b that involves fraudulent conduct by you, the lawyer, and by not correcting the record of your client, how does that really impact the lawyer as opposed to in the record that you're establishing here? From Jeff.
Well, Mary's point is the lawyer's not done anything to engender this false opinion. There's no general duty to correct errors of opposing counsel or of the court. No general duty, especially when the source of your knowledge is a protected area. You also got to worry about 8.4. Is this conduct involving dishonesty, fraud, deceit, or misrepresentation? Certainly not misrepresentation, but is it deceitful? You know, if they really want to get you, is this conduct unbecoming? These are very vague kind of terms. They could say, well, your being silent was deceitful, and because you knew the judge was relying on you to correct his misapprehension. That's the exposure I think the lawyer has.
I think the exposure isn't a real one for purposes of discipline, but it is in an adversary system. You know, the question is somebody going to use this on you somewhere down the road? And I think you really have to worry about that.
Okay.
We have somebody thanking Mary Robinson for her insights and saying as a criminal defense attorney you should not be volunteering information about your client, that it's a state's obligation to present the evidence against your client. And another person wrote that if the state were to introduce it, though, that it would be a motion against it would be sustained.
Okay, we have time for one more in-house question.
Yeah, my impression is, or my view is, that you're not obligated to do the judge's work for them or the opposing counsel's work for them. It is your job to see that what you say and what your client says under your guidance is correct. But if somebody's, floating in la-la land, you're not paid to correct everything that is said in that courtroom. It's to not present something you know is not true.
You agree, Mary?
I do.
Okay. All right. Hypothetical number 5. You represent the manufacturer of the scaffolding in the products liability action. You are the only trial lawyer. During a recess in the trial, you notice in the courthouse lobby a person whom you recognize as one of the plaintiff's co-workers whose deposition you took some months ago. At the deposition, that witness testified that the scaffolding was properly assembled by the plaintiff and that the plaintiff generally acted with due care. He approaches you in the lobby. The witness approaches the lawyer in the lobby and he says, quote, "I can't believe you are fighting this case. Who the hell cares whose fault this was? Your client has the money to cover this and the plaintiff does not. That's all I care about, and that's why I will stick it to you when I testify. If you ask me about this conversation, I'll deny it. Who would believe a lawyer anyway?" Wow. You are the only witness to these comments. So, question. May you or must you confront the witness with his statement on his cross-examination? Again, the witness is there, going to be called by the plaintiff to testify. You get the opportunity to cross this witness. And should you ask the permission of the court before you cross-examine the witness as to this conversation? And if he denies making the statement, may you or must you testify? Wow. Your Honor, have you ever had anything like this?
No, not that I can remember. But I don't know what. First, the hypothetical says I'm going to stick it to you. I'm not sure I know what that means. But it would strike
I'm
me.
from the south side of Chicago. I think I know what that means.
Well, so am I, but it would strike me that you definitely bring it up with the court. I assume this isn't your witness, because you could have them declared an adverse witness if under the appropriate circumstances. But I think I would definitely bring it up with the court. I would tell the court about the conversation. I would, suggest you proceed with your cross-examination. You bring it up, see where it goes, and I think in this case. I've heard of times when lawyers have, in the Daily Center, one comes specifically to mind, that got on the witness stand in the middle of the case to contradict what a witness allegedly said to him out in the hallway. Well, I've never had that personally, but I know it's occurred. I think the theory behind lawyers not being witnesses is basically it confuses the jury. Are they being an advocate, or are they testifying as to a factual matter in the case? And in this limited circumstance, I would think it would be appropriate if the lawyer wanted to do that, to go on the stand for this very limited purpose. And I don't think you'd confuse the jury, because it's limited to just this conversation. So I would leave it to the experts, though, if I'm wrong as usual. But
no, I think that's the right answer. The question is, the problem is, if you ask the judge ahead of time, the judge said, no, you're trying this case. You can't be a witness in a case that you're trying. Rule 3.7 says that a lawyer shall not act as an advocate in which the lawyer is likely to be a necessary witness. So it has an exception that applies, I think, to this case. If disqualification would work a substantial hardship on the client. And, the lawyer didn't bring it upon himself. This was something that landed in his lap. And so I think that exception allows him to be a witness. The problem is if you have a judge who disagrees with that, this is the problem about clearing it with the judge ahead of time, and the wisdom of doing that. If you think the judge is hostile to your position, he could say, no, you can't testify in this case. I don't think there's any hardship. And so you can't complete this impeachment. You can't confront him on cross because I'm not going to let you testify. And so you can't do it at all. And this is important impeachment. It shows this witness is hostile to you. So that's the problem, I think, that the hypothetical raises. But I agree that that's the proper course. And I think the only question is, do you clear it with the judge first, or do you just do it? So is it better to ask permission, or better to say you're sorry? Because that way you force the judge's hand, in effect.
Well, looking at it from the lawyer's perspective, you know, if you're going to bring it up, if you make the court decision to bring it up, and once again, Judge, this was a case where it's the plaintiff is calling this witness, now the defense lawyer is the one who this happened to him or her, and she's going to cross-examine this, and, you're a biased witness. Didn't you just tell me that you're going to stick it to my client? Right. Now if I was the judge and I heard that, I think I'd go a little nuts saying, hey, counsel, what's a little sidebar here? Talk about this. Yeah. Is it, Mary, have you seen situations where a lawyer was criticized for trying to inject herself into the trial?
No, I really don't think that is the problem. The real problem is, what do you do for the trial? I don't really see that. Most of the time, whether the lawyer's ability to act as an advocate and a witness is going to be controlled by the judge. Do you know what I mean? It just isn't something that transcends. Can I add a random fact here that I was glad to hear and didn't know until I studied this, that if a lawyer may be a witness on a critical matter that may be, that would disqualify the lawyer from acting as advocate, the lawyer can still represent the client up until the time of trial, which is really good for your clients. Do you know what I mean? You have to have somebody else come in and actually do the trial, but just because you're going to be a witness doesn't mean you're disqualified from the pretrial.
But why are you, okay, but wait a minute, just because I'm going to be, I don't want to be disqualified from the trial.
Well, I'm not saying...
I want to be a witness and I want to be able to be the trial lawyer. Why can't I do that?
Because the rule says you can't, and the judges are going to enforce it. And it's also a rule of evidence for exactly the reasons that the judge gave us.
Now, it's not imputed, though, so,
right.
Other lawyers in your firm doesn't raise an issue anymore, used to, if another lawyer in your firm has to be a witness, it's not the most objective, unimpeachable witness, but nonetheless, there's no ethical prohibition.
Well, let's look up the rules. I mean, pull 3.7 up. It says the lawyer's witness, a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be necessary witness unless disqualification of the lawyer would work substantial hardship on the client.
Right.
I mean, doesn't there have to be, before I unilaterally decide that I'm not going to be the trial lawyer, that I make for lack of a better term, a proffer to the court? This is the scenario that you're going to hear play out, and I don't think that this ought to disqualify me because this is a file that I've been handling for 7 years. There's 137 depositions. There's 1 million documents involved. Hundreds of thousands of dollars have been spent preparing this case for trial, and that will create an enormous hardship on my client. And I want you to hold, if you're going to do anything, I want an evidentiary hearing on whether or not that hardship exists or not. Can't I do something like that?
Yes, I think that's a winning argument.
It happens all the time. I think that the rule is really designed to warn you when you know something early on. Mm-hmm. You're not going to be the lawyer,
Right.
But when you're right at the cusp or in the middle of the trial,
this one there is in the middle of the trial, right?
Then I think that I agree with Bob.
Yeah. Okay, cool. Now, Bob, by the way, you've prepared a first series of hypotheticals. Are some of these based on actual cases?
Yes, that they are.
Yeah. Ones that you've worked in? I mean, have the results been any different or any twists that you can share with us?
Not because of my duty of confidentiality. I would be inclined to, but yeah, these all come out of real cases. They're somewhat some of the details are changed, but these things really happen.
Wow. Here we go. Well, let's see about Mr. Garvey. So you represent Thomas Garvey, hypothetical number 6 now. You represent Thomas Garvey in a strong arm robbery case. Garvey told you throughout the time that you've been representing him that he had been drinking heavily on the night that the robbery occurred. He has, however, consistently maintained that it was his friend Peter Quinn, with whom he had been drinking, who acted alone in threatening bodily harm to the victim before taking the victim's wallet. Garvey has claimed that he stood off some distance and was not involved when Peter Quinn was threatening bodily harm. You have thought this story to be implausible and not likely to be believed by the jury, but were prepared to call Garvey to so testify. A day before trial, Garvey meets with you and says, "I can't tell that story. Quinn will kill me if I do. We are going to have to do something else." Garvey proposes to take the stand and testify that neither he nor Quinn were present at the robbery, but were driving some blocks away. He tells you that Quinn is ready to say the same thing. He says to you, "As far as you know, that's what happened. You weren't there, right? That's my story now, and I'm sticking to it." May you present that testimony. Wow. Professor, you're telling us someone tried to do this?
It's hard to believe, but that's all I want to say.
Okay.
That's my story, and I'm sticking to it.
Let me say this. Full disclosure, I was a criminal defense lawyer for 18 years before I went to the ARDC, and criminals are not the brightest lights.
Okay.
Right?
So let's assume that you conclude that the better course is for neither Garvey or Quinn to testify, and to attack the identification evidence by the witness through vigorous cross-examination. The description he gave the police was very limited. You can suggest that he omitted some striking features of both defendants and that the initial identification was suggestive. You propose to give an opening statement in which you say, "The evidence will show that the first involvement Garvey had with this matter was when the police stopped his car 7 blocks away from the robbery. You believe that Garvey had involvement somewhat earlier because of what you've been told." May you give that opening statement.
So you've got 2 problems. To go back to this first one, the question is, the thing we've been talking about, do you know that the testimony that Garvey proposes to give is false? Because he's changed his testimony so radically, can you say, well, I wasn't there, if that's your story? Or have you now reached the point where you know that his proposed testimony is false? And there's a Wisconsin precedent, State versus McDowell, Wisconsin Supreme Court, and basically says, if it's a criminal defendant and the criminal defendant says anything other than, at the time of trial, I'm going to testify falsely, and so it's no matter how circumstantially likely it is that's false, your obligation is to put that client on.
So wait a minute. So you're saying that if the day before the trial, you've been handling this case now for a long time, the client comes to you and changes his story.
Right.
You're entitled to conclude that the second story is correct?
In Wisconsin, you're entitled to conclude that the second story is correct unless you know that it's false. And in Wisconsin, you know that it's false only if the client tells you then and there it's false. That's not the dominant rule throughout the country. You can know that a story is false without basically on circumstantial evidence because the story has changed so radically. It's implausible. So I know it's false even though he's now saying it's true. So that's where the line is, and I think that's the more general rule. A lawyer can know that a story is false even if at the time of trial the client says it's true.
Judge?
This is just a question because this is, again, out of my field, but Rule 3.3 says a lawyer shall not knowingly offer evidence they know it to be false. Then it says at the end, a lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. Isn't that pretty much what you just said?
It means there's a distinction for the criminal defendant between reasonably believing it's false and knowing that it's false. And in Wisconsin, you know that it's false only if the client tells you, I'm going to testify falsely. But this
You've got to use those words almost, as opposed to telling you a different story.
He almost has to use those words, but that is not the dominant rule throughout the country. I think.
Well, what's the rule here in Illinois? We're not in Wisconsin.
It's true. I think the rule in Illinois is that a lawyer can know that proposed testimony is false, even though the client is saying it's the truth. And so there can be a level of circumstantial knowledge of the falseness of proposed testimony that prevents you from offering it, even of a criminal defendant, even if the client implausibly says at the last minute, no, this is true, what I said before is false. The standard is high, but in most places around the country, including Illinois, it can be met. It can be met without an admission.
Your Honor?
See, so when I read this, I kind of thought maybe you could put Garvey on, your client, but not put Quinn on, who was a witness, because there's distinction in the rule. Would that be correct?
Well, I mean, if you don't know that the testimony is false, so that's the distinction. It's an awfully refined distinction, but it's the distinction the rule makes.
George,
if it's a criminal defendant, you've got to know it's false.
George online?
George online says, I thought if you know the testimony is being fabricated that you have a duty to advise the defendant not to testify. If the defendant insists on testifying, I thought you must present this defendant's testimony in a narrative form and ask the defendant to tell the court what happened without asking any further questions.
That's the rule in California. Illinois has adopted the model rules now, and now the prohibition on offering testimony that you know is false. And if you offer testimony that you come to know is false, you have to take reasonable remedial action. Terrible position to be in.
But it does. I mean, the rule. Here's what the comments is, and it's what you're trying to. Because of the special protections historically provided criminal defendants, and that includes the right to counsel, and it includes the right to testify, and it includes the fact that courts don't want a headache with reversals of convictions. Put that on the table as an important consideration. But then it says the rule does not permit a lawyer to refuse to offer the testimony of such a client where the lawyer reasonably believes but does not know that the testimony will be false. Unless the lawyer knows the testimony will be false, the lawyer must honor the client's decision to testify.
Well, let me add in this fact, because it might be the right time to do it. So the third component of this hypothetical, There's someone named Matthew Roberts, and he was drinking with Garvey and Quinn on the night of the robbery. He is prepared to testify that Garvey and Quinn left the bar where they were drinking at 1 a.m. The robbery occurred at 12:50. Roberts appears sincerely to believe that Garvey and Quinn left at 1 o'clock, and so would not be perjuring himself. You strongly believe that he is wrong. May you call him to testify? Sounds like the answer is yes.
I'm not so sure about that.
Well, okay.
Because the question is, do you know it to be false? What does that mean?
Well, that's
that what he's saying is false, or that he thinks it's false?
Well, then, if you're going to say that maybe he can't, then how do you draw a distinction between that answer and what I asked for the first one, and that is where the guy comes in and he's got a whole brand new story. You have no more evidence that you know about this one being false and about that one not being false.
But this is what the judge asked. This is a witness, not your client.
So there's a
I
big
think
difference
that's
if it's your
different.
client.
The standard becomes very high. It becomes knowledge. I think you can unfortunately know that proposed testimony is false, even if your client says it's true. But standard is very, very high. Here, you may decline to offer this testimony if you reasonably believe it's false. That's your prerogative under the rule, because it's not your client, it's not the criminal defendant. And you might say, well, maybe they're wrong about the time of the robbery. Maybe they did leave at 1 o'clock. So there's this question about who's right and who's wrong here that might give you some leeway. And so there's that variation, that variable as well.
Okay.
But one thing is clear: if you know that it's false, even if the witness reasonably truly believes it, is not perjuring himself, is sincere about it, but you know he's just wrong, you can't offer it if you know that it's false.
We have one question in the audience.
Yeah, I mean, the problem is we're playing games with, you said it, but you don't know whether he quite said it well enough or not enough. I think that what you try to do as a lawyer is to understand what happened, formulate an image or a picture in your mind of what happened, and present evidence to support that case. Or if you say, this guy didn't say it quite loudly enough and he said it too softly, now you're playing games as opposed to trying to present the evidence of what actually took place. And I think that's your fundamental job, to do it. And if you can't do it and represent your client, then you don't take the case. Otherwise, you're being the worst image of lawyers that there is, and you're not trying to ascertain the truth.
Yeah, but Gene, the reason these things come up is because of many defense attorneys are appointed. They are forced upon their clients. Okay? It's a difficult relationship.
Give him the mic, please. Thank you.
Yeah. Okay. What in this scenario you decide you can't rely on anything your client told you because he's changed his story too many times?
Then you don't know. Then you may not know that his current testimony is false. I don't know what to believe.
Is there ever a time, though, that, apropos to that, ever a time when it becomes, I'm so flummoxed by all this that I just can't represent you. I got an irreconcilable difference with you. I don't want to represent you. I don't know if you're telling me the truth or you're lying, and I'm not going to, allow my good standing with the court to be compromised by you. Can I do that, Professor?
Well, I have a range of views on that. I think the answer, the disciplinary answer is yes. You can say, I now have a fundamental disagreement with my client, which is the standard under Rule 1.16. I can't go forward. I've lost confidence in my ability to present this case in a fair-minded way. I'm going to seek leave to withdraw. You can always withdraw if the client suffers no burden from that withdrawal. You may withdraw even if the client is going to have to pay some more money, for example, if you say, we have a fundamental disagreement. Some lawyers who do criminal defense say the client must have really treated you unfairly to reach that point.
Okay, Judge?
Well, the comment on Rule 3.3 says that a lawyer should resolve doubts about the veracity of testimony or other evidence in favor of their client. So I guess that gives you kind of a burden of proof standard that if you don't know, you resolve it in favor of your client.
We have several questions on the web here,
Okay.
or comments. How much certainty, in your knowledge, do you have to have as a defense attorney to justify denying a defendant his right to present his defense?
I'd say pretty near certainty.
And then we have from John, it's the jury that finds the facts, not the witnesses. Another person is saying here, Ron, one procedure has been for the lawyer to move to withdraw when the defendant insists on lying on the stand. If the judge denies the motion, the attorney only asks the defendant a general question, and the defendant then testifies in narrative form. The defendant has an absolute right to testify. Isn't that the correct procedure?
In California.
Again, in California?
In the United States v. Nix, the United States Supreme Court said a client does not have a constitutional right to testify falsely. So if the lawyer knows, and that's the rub here again, knows that the testimony is going to be false, the Nix case says there's no federal constitutional right to present false testimony, even when that comes from a criminal defendant.
And John says,
much
Wait 1
criticized.
second, Pam. We'll go back and forth. Question in the room, and then we'll come back here. Mr. McCarthy?
What if, not so hypothetically, the judge looks at you when you say, I want to withdraw, and the judge says, no. Now what do you do?
You're back where you were. You're in a situation where you may not knowingly present false testimony. You can present testimony if you just believe it's false, but you don't know it's false. And I'm sorry, that's not very satisfying, but that's the distinction that the rule imposes.
Question back to the web.
and John is saying, can't the lawyer rely on the fact that these three goofballs were drinking heavily and no one might be telling exactly what really happened?
That one sounds pretty good. Yes, sir. Can you speak loudly?
Yes. First of all, thank you for participating today. I do have a question, though. Aren't you essentially placing yourself in the shoes of the jurors in the box? So you, as an attorney, don't have to subscribe to your client's political, religious, personal, moral views. And when you're represented or even hired to represent them, you don't know whether or not he did something or not. Now, there's a difference between knowledge and reasonable belief, but generally speaking, as an attorney, you are not present. So aren't you allowing or maybe usurping the jury's function and having this wonderful esoteric conversation? I mean, if you have knowledge, that's one thing, but you don't know.
You sound like the Wisconsin Supreme Court.
My former employer taught me well.
There you go. Okay, we have a question in the front row here.
In today's environment of wrongful convictions, what's the distinction between a prosecutor facing the same witness inconsistencies and a criminal defense attorney?
Huge distinction.
Repeat the question.
The question is, and you said in today's world of wrongful convictions, we don't need that as the condition of the answer. Okay, what's the difference between being a defense attorney and a prosecutor? And there's a big difference regardless of what day you're in. And it is that the prosecutor is by rule and constitutional law required to seek justice and not seek convictions. And our Supreme Court put a specific phrase into our Rule 3.8. There's a special rule for prosecutors. And our court threw that proposition into the rule, even though it's not in the model rules, to make a point. So the prosecutor doesn't have any of these concerns about a client who has some constitutional right. The prosecutor is absolutely forbidden from presenting evidence that the prosecutor knows to be false. And the prosecutor is going to have a much harder time if somebody comes and looks at this in hindsight and tries to identify what the prosecutor knew when the prosecutor was putting it out. And I'm going to add another thing. You know, I told an Innocence Project that when I was practicing in the 70s and the 80s, there was no such thing as a wrongful conviction. Okay, mind you, no such thing. Nobody believed it, all right? And then there was DNA, okay? And, you know, in most of my career, there's been no such thing as a lying police officer. And now we have video cams, you know? I mean, today the video cam is the DNA for the federal civil rights litigation. And one of the things that's nice about the scientific and the electronically recorded history is that we have fewer of these what do you know moments. You know what I mean? You know a lot more when it's on a videotape. It helps a lot.
Okay.
We have one more question from Jim here on the internet. It says, if you could please address counsel's dilemma in deciding whether to ask the client about what he said was false.
Never. No.
Well, that's a good point. So when the guy comes to you after he gave you the first story, and then, I mean, are you telling me that I can't say, well, wait, Charlie, you told me X the first time we met. Now you're telling me Y. Were you lying to me then, or are you lying to me now? Are you saying you shouldn't ask that question?
Oh, I'm saying it's not a good strategy. I'm saying that what I try to do is say, my goodness, I never say that to her, but I say, I'm looking at this, and I'm looking at what you said here, and I'm trying to make it all hang together.
I mean, isn't that being deliberately dumb? Come on.
I'm not being deliberately dumb. I'm giving them the chance to take to first of all see reality, and then assess what they really remember.
How is that different than me saying to a guy in a civil case, Mr. Smith, if the light was green, you win. If the light was red, you lose. What color was that light?
No, I'm not trying to do that. I agree with you. No. I'm not talking about that. I'm just saying that we remember things. If you ask the neuroscientists, they will tell you our memories are not computers. All right? They don't capture everything. And what will happen is that when we try to bring up a memory, we have a few pieces, and then we keep trying and we keep getting more pieces. We reload information. So if you ask me something today about something, I'm going to say one thing to you. And if you ask me about it in a week, I might describe it differently. And in fact, one of the tests, those who are taught how to interrogate, one strategy that they're taught is that somebody who repeats the same thing every single time is not telling you the truth.
The tough issue, I think, is exactly the one that Bob mentions, is to what extent, so you do have this obligation to try to believe your client if you can. And so what does that mean about you're pushing your client? You're doing a little cross-examination. Are you serious about this? To what extent do you have to extract from your client the statement, yes, it really is the truth? Or can you back off from that and say, into yourself, now I don't know what to believe. He's the client. I have an obligation to try to believe him. I can't say that I know his current story is false. I'm going to present it. To what extent is that okay? And to what extent must you engage in a kind of cross-examination, a kind of probing challenge to your client on ethical grounds in those situations? I think that's the hard part.
Okay. All right. Well, then this is getting good.
Well, we have
one
Kevin
more question
asking
on the web.
Kevin is asking, how does a court or jury view using a deposition against your own client or your own witness?
I don't know the answer to that. I don't quite understand the question.
Is that impeaching your own witness?
Yeah.
Right.
Well, it can be done.
I think
I don't know. I think there might be a big difference between whether it's your client and whether it's
your client,
a witness,
or your witness.
Yeah.
I would notify your carrier before you did that.
There we go. All right, let's move on. And I couldn't help but think, as Mary was describing, DNA and the evolution of that, and now the cameras and the evolution of that, and certainly in my world, the evolution and significance of email discovery in litigation is a subject unto itself, and we're going to get into it a little bit here with hypothetical number 7. You represent ABC Corporation in a sexual harassment lawsuit where the alleged harasser is ABC's CEO. The accuser asserts that the harassing conduct of the CEO has so traumatized her that she has been unable to engage in any intimate relationship for years. You have interviewed the CEO's administrative assistant, who believes that the accuser is lying about everything and who insists that the accuser has very active and a spicy romantic life. After you suggest that it would help to have some evidence, the administrative assistant sends you a packet of several emails apparently sent by the accuser from a private email address to a number of different men full of lurid recounts of trysts. When you ask how she obtained the emails, the administrative assistant makes some vague reference to friends in IT. If the emails are authentic, they should have been disclosed by the plaintiff in discovery. What do you do with the emails? Mary, you giggled when I said emails, so you get to go first on this one.
Yeah, I know. It's something that I have learned to be very careful with, but it's harder when you're younger. You know what I mean? I don't put a lot in emails, and I think that we find that, like you say, this is where we're spending a great deal of energy and time. The problem here, though, is not what you can do with these emails. The trouble is, how did they come into your possession? And based upon what this administrative assistant has told you, these were from a private email address. So not likely something that the company had the right to access. And when you ask her about it, she says something vague about IT, and that strikes me as a suggestion that somebody illegally accessed these. And we threw some of the criminal statutes into the materials. There are many very, very, very specific and somewhat onerous criminal statutes, both state and criminal and federal, that make anything that we would use the term hacking illegal. So I would say that on the face of this, you have every reason to believe that these emails were obtained illegally. And then the question is, what can you do with them? And my advice when clients ask me this is to bury them, shred them. You have no right, you cannot use them. Even though if these are real, the plaintiff should have disclosed these. And you've got a nice little ace in your pocket in terms of your opponent having failed to give you something.
Well, but that's a good question. Wouldn't that lead to this discussion of the fruit of the poisonous tree? I mean, you now know about this stuff, right? And you just said, okay, let's shred them, pretend they didn't exist. Right. Yet you kind of did read them. And they may have given you a direction or two of inquiry or discovery that you might want to go to now. I mean, is there anything wrong in you doing that?
You already had evidence that would have caused you to look in certain directions.
Come on. You know that there's an email from the lady to Mr. Smith over there. I'm looking right at him. And you're not going to hit Mr. Smith with an email?
Subpoena.
Or subpoena?
That's a different question. I think I'm going to defer.
Professor, what do you say about this one?
Right.
Get Mary off the hook here.
A couple of things that's not. I mean, you didn't, at least overtly, put the administrative assistants up to violating the criminal law, and you didn't put her up to a method of gathering evidence that violates the legal rights of another. That's prohibited by Rule 4.4. It's come to you. You're innocent. I don't believe there is a fruit of the poisonous tree problem here. Someone has acted perhaps criminally to your benefit, but I don't know that I would certainly pursue obtaining an admissible form of this evidence, and wouldn't feel bad that I have this information and it enables me to do that. So I don't think there's a fruit of the poisonous tree problem here.
So Judge, I represent Mr. Smith. I see the subpoena. I know doggone well what they're looking for. There's no possible way that they knew of my client's involvement with this lady. I go in on a motion to suppress this subpoena because I don't know where they got it, but they know something they're not supposed to know. What are you going to do about that?
Well, I'd be inclined to deny that motion. I mean, this is a good one. This is really a good one because don't forget the fundamental issue here is that the plaintiff is concealing evidence and is trying to deceive the court, the process, the trier of fact ultimately. No, I think if this assistant had said to you, I think she was fooling around with Mr. Smith, and then you subpoenaed Mr. Smith. I mean, why can't you follow leads? And I mean, if you took it all and you said, geez, I think you got this illegally, take it back. But now Mr. Smith is a potential person. And again, this is assuming that these are valid. One thing that this email and this ESI, you get into that metadata because so much of it looks like it's valid and it isn't. So we don't even know if this really was valid or she somehow did it. I don't know. But in any case, I think as a judge, in the fruit of the poisonous tree, I thought that was a criminal concept. But as a judge, I'm trying to be a truth seeker. Yeah. And I'm trying to get to the truth here, and I'm not real comfortable with people trying to get there by illegal acts. That's not good. But I'm not happy to hear people are not complying with the rules of discovery. And so I'd probably deny it and let it go where it is, and let Mr. Smith see what his emails have to say.
We'll get to the question in a moment, but Mary, does the counsel here, with a reasonable suspicion that this information was acquired illegally, what if any obligation does the lawyer have to address that issue? Right.
To the extent that the lawyer has any obligation, in my opinion, it would only be under Rule 113, which is the rule that identifies our duties when we represent an organization. Right. This lawyer represents a corporation. And the lawyer would, if the lawyer believes that this, the assistant is engaged in, not was engaged in, but continues to be engaged in conduct that could result in substantial injury to the organization and could be attributed to the organization, both of those, the lawyer is supposed to take reasonable steps to stop it. Okay. So what you would do, typically, you could start by saying, whatever your name is, honey, this is a really bad idea. And I don't think you want to ever, don't do this again. And I'm warning you,
When you went up the ladder to the CEO, I don't think his heart would be broken. And right. I think the administrative assistant really won't suffer very much.
Someone's got some mic on the right here. Here we go.
What stood out to me was the term private email. If an employee is using their private email in their corporate setting, the computer owner is the company. So it seems to me that there's a reasonable duty to investigate the second side of the email. In other words, if someone is using a private email at the company, clearly the company can access what the person looked at. They would then need to invoke discovery or a subpoena to see the whole email account. Right. And I don't even see that as an ethical issue because...
I'm going to tell you, what you said is not universally accepted. I think that is the result in some jurisdictions, but it is not the result in other jurisdictions.
No, I meant the initial inquiry, the ethical responsibility of the attorney to zealously represent his client.
No, I mean about the impact of using private email on company computers. All right, that's an issue that can be open. I just want you to know.
Can't law firms say, okay, we're in the same law firm, and you're the executive committee, and you decide that whatever emails you send while we're all working, you have no expectation and no right of privacy. Can't they do that?
Sure, they can, but if they haven't, there might be an expectation of privacy, okay. And then it could be, and we don't really know from this hypothetical where the IT person got it.
Yeah, okay. That's okay. We're causing the question to be asked. Okay, we got a gentleman in the back and then a gentleman up here.
Thank you. As Professor Burns may recognize, the facts of this hypothetical are very close to the facts of the case presented at Northwestern's minor moot court competition this year. And according to the bench memo in that case, there is a doctrine called the private search doctrine, which says once a private search has been made of something like emails, the expectation of privacy has gone away. It then allows the authorities in the criminal case to come in and look at anything there without getting a warrant. And so I would imagine that that doctrine could be applied to this as well. Once the administrative assistant had gone and looked at this, the expectation of privacy is gone, and this could be used in whatever manner counsel feels would be appropriate.
Okay. Gentleman up in the front row, get a hand on the mic. Do you have a question yet on the computer while we're doing that?
If a question is asked by Bill, isn't this a document that you may now need to produce in discovery as being in the client's possession, custody, or control?
I think the high road is not to use it. I mean...
Yeah, but I don't think that's the question. This is not high road stuff. Hey, come on. No, come on. I mean, you were given, the lawyer's been given the documents. He read them, okay? Once the lawyer's got them in her paws, you know, doesn't she have an obligation to give this information to her, you know, her opponent?
Supplement the discovery.
Yeah. I mean, what's the rule?
I don't know. I mean, if this is responsive to a discovery request, that may be true.
Might be. Yeah.
But, you know, can I add another thing?
And again, our goal here today is to cause the questions, the issues to be identified. We don't necessarily have all the answers here.
Right.
But I can tell you, you know, there's a case I'm working on currently where at issue are emails that were literally extracted from discarded garbage. And retired FBI agents were going through garbage bags of email to the point where they knew the pattern of how they were discarding the emails, and they would supplement and replace the bag so that the person discarding this stuff never knew about it. I mean, this stuff's real and it's out there, and there are legitimate issues that you have to deal with. Yes, sir, you.
Sure. My question goes back to what you said with Mr. Smith's attorney comes in and files a motion to quash the subpoena. The judge says, okay, you know, what's your basis for sending the subpoena to Mr. Smith? Now, what duty do you have issuing it to the secretary that brought you these emails to say, well, I think she illegally got these emails, I shredded them. You know, that's the basis I'm sending this subpoena to Mr. Smith.
Well, my argument would be that, okay, so the subpoena was issued to Mr. Smith. There's no evidence in the record that would indicate that he's a witness at all to anything here, and therefore it's a frivolous discovery that I want to. What right do they have to take this guy's deposition? He doesn't know anything about this case, and if you're going to say that he does, then don't you have a duty to proffer something to the court so the court knows that the subpoena is issued in good faith? That would be my argument.
Right. And is that, can you relay on these emails that you think were received illegally?
Yes.
Yes, the professor says yes.
I agree. You know, I want to. This one isn't as clearly addressed in the rules, but there is a rule. Illinois did adopt the rule on inadvertent disclosures.
Yes.
You know, and the rule gives us this edict. If something lands in your lap and you think it was privileged and wasn't intended to be sent to you, you know what you have to do with it?
Give it back.
Nope. You have to tell the other side you have it.
Well, Mary, let's talk about that real quick. Interject
right.
here, because you know, again, with email discovery, and there are a lot of programs about email nowadays. But it certainly has been happening to me a few times in the past 6 months where I've received an email, I open it up, there's something in it that's an attachment, and I don't have time to go in it, or I do, and then all of a sudden I get a recall. Charlie's recalling this email because he didn't mean to give it to me. What's my duty?
Under the rules, you only have to say, I have it.
Okay.
I have it. You don't have to give it back. Now, whether you can use it or not is...
Losers, weepers?
Well, it's very complicated, but I think the theory is that if you tell them I have it, and they know you have it, they can take the appropriate action to neutralize what you're able to do with it.
Yeah, then the court's going to have to decide whether whether that party has waived a privilege based on the inadvertent disclosure, and rules are quite different on that.
And this applies even to attorney-client privilege?
Yes, even that. Because if you give it up voluntarily, you might be found to have waived it.
There's a new federal rule that basically allows a lawyer to maintain an assertion of privilege if there's been an inadvertent disclosure.
In fact, the new federal rules they're hot topics right now, worth studying. There are a lot of programs out of late about them. National Law Journal is having several webinars on the new federal rules. So, all right, well, let's get away from emails for a moment and maybe talk a little bit about the communications with a person who's represented by counsel. So in hypothetical number 8, you represent a corporation in a series of employment discrimination cases. One was brought by an employee X who worked on loading docks. Employees Y and Z are potential witnesses, and you schedule their depositions. About a week before the deposition of one of them, number Z, you are told that Z has filed his own discrimination case against your client, and he's represented by Attorney Jones. You see a copy of a complaint a couple of days before the deposition. It hasn't been served yet, but you found a copy. And he recognized that there are some areas of inquiry common to both X's case and Z's case. So Z appears for his deposition without his lawyer because, once again, he's there responding to your subpoena to him to be at the deposition. He's doing that in the lawsuit that where he's a witness, and yet now you know that he's got his own complaint on file, and you're going to start asking him a bunch of questions about that complaint in that case, even though you know he actually has a lawyer, and that's Attorney Jones. That's the fact pattern. So my question to you is, and Jones shows up, can you in fact start asking him a bunch of questions about the lawsuit he filed by counsel, and counsel has no knowledge of this deposition because Jones wasn't aware of the fact that his client's showing up at your office? Wow, Professor?
Well, talk about the rule in a second, but I think the common sense and courteous thing to do would be to communicate this information to the counsel, to the witnesses' counsel.
We're talking about what are the rules?
We call it civility these days, but it's. I mean, this is a situation where put aside courtesy and civility for a moment, and good diplomacy in terms of the case, but the rule requires you to seek the permission of the lawyer who represents a client in the matter. There's a little bit of fudge room here about whether or not he represents this witness in the matter, but I don't think there's that much fudge room. I think this is a client who is represented in the matter. These rules are very ruthlessly enforced because lawyers are very protective of their clients, and so there'll be a hopping mad lawyer on the other side of this.
Yeah, but it's a personal problem he's going to have to get over. I mean, this is not the matter. This is not the matter. This is a separate lawsuit. He's got his own lawsuit. We'll get to the question in one moment. Judge wanted to jump in, I thought.
Well, it's a separate matter, but I thought these questions were involved with the matter that that the lawyer was representing him on.
He's been hired to be the employment discrimination lawyer, and there just happens to be more than one case against the company.
I still think that the rule applies. This is a deposition. You can always continue, unless you're trying to get an unfair advantage. You just continue the deposition.
Precisely what the lawyer is trying to do.
But, the comments to the rule say the rule applies even though the represented person initiates or consents to the communication. The lawyer has to consent. The lawyer has to consent, not the client.
So the remedy is a motion to quash the dep once it's been taken, probably?
The remedy was not just that, it also was to sanction the lawyers. The lawyers were sanctioned both by an angry federal judge who got a good news story out of it, and then by the ARDC, or by the Illinois Supreme Court.
And this rule applies even when the represented person initiates the conversation with the other lawyer. Right. You still have to clear it with that person's lawyer. Maybe there's some level of confidence when he says, no, I have talked to my own lawyer, and he says it's fine. You could believe that if you really want to be careful, you'd say, okay, fine, I'm going to give him a ring and I'll get right back to you.
Question in the front row.
There was a case like that.
Well, that's where Mary got it from.
I got a case on the case went forward, and then there was something about the statute of limitations that they could not use that. They were waived.
Oh, I don't remember that, but clearly it resulted in very dire consequences. And, you know, Bob's point is well taken. Lawyers enforce this rule with vigor. And it is one of the few that I would say never take a chance. Never take a chance.
The tough issues actually are where there's a represented corporation. Which of the employees of that corporation can you interview ex parte? And there's an answer to those questions. You find it in the comments to Rule 4.2.
As a general proposition, Professor, do you recall where the line of demarcation is? Those that you can, those that you cannot?
Yeah, currently it is officials, executives in the corporation who basically direct the legal position of the corporation, and employees whose act or omission can be the basis of the liability of the corporation. It used to be those parties who could make admissions against the entity, but the federal rule has gotten rid of that because now under the federal rules of evidence, all employees just about can make admissions against their entity, against the entity. So you could interview someone who is not a top executive and not someone whose act or omission is the basis of liability, even though something he says might be an admission of a party opponent.
Does that test, the control group, still apply in your view?
In Illinois, it is the test, but it's different than what you're describing, right? Most states have it's a harder. I think what you're saying is harder to figure out who it is. In Illinois, it is the control.
Well, here's something that's going on right now. So, and it can be at various levels, whether it's high ranking or not. Former employees leave a company. Now we want their depositions. We subpoena them for depositions. And the company on its own, or the insurer on its own, my words now, solicit the representation by knocking on the employee's door. Well, tell me about it. They knock on the employee's door and say, hey, we know that you've been subpoenaed for a deposition in this case, and we want to be your lawyers. How can they do that? That's going on in corporations. That's going on in medical malpractice cases all across the state. You think that's right?
Well, I mean, go back to the basis of this, because former employees are not covered by 4.2. Their privileged communications with their former employer are still privileged, and you can't intrude upon those, even at a deposition. The offering of representation would be parsed out under the solicitation rules,
Don't you think it is? Yeah.
It is solicitation, depending upon And there's a question too about interfering with the representation, with the discovery of the other party.
Yeah. Okay. All right. So we have two questions in the audience, and as soon as you're done with the mic, would you hand it to the gentleman in front of you? Yes, sir.
I have just a question about the scope of representation. How far does that go? Imagine you're opposing a plaintiff in a personal injury case. Plaintiff claims lost wages. You start to ask about his employment, and he says, oh, yeah, and I'm suing my employer because they fired me both because I couldn't work and because of sex discrimination, age discrimination. Can you continue asking the plaintiff about his employment when you know he has a lawsuit related to his employment pending?
Judge?
Well, but he's represented at the deposition by his or her attorney. I don't know that you have to bring in the companies.
It's pro se in personal injury. But not pro se federal employment.
But you're not a party to the federal employment case, are you? No. Yeah, I think you can ask them. Yeah.
Good.
In the deposition context is not the usual context for this. It's usually interview, an ex parte interview, ordinary interview, in which you cull off someone who's represented and have a face-to-face interview without the protections of a deposition.
Okay. Good. All right. Yes, sir.
Bob, in your comment about the unsolicited, generous offer of representation, maybe there's a conflicts issue where the attorney really has the best interests of the corporation at heart as opposed to their newfound client who's going to be the witness for them.
Yeah, it would be an interesting disclosure and waiver conversation under 1.7. which can be very demanding on the lawyer.
All right, we have a question from the web.
Right, just to wrap up this issue is, so then on this hypothetical, do you have to reschedule the deposition or just call his attorney's office?
You call the attorney's office. And if the attorney says go ahead, you go ahead. But if you don't reach the attorney or the attorney doesn't agree, then I would reschedule.
Thank you. That was from Monica.
I still don't know about this one.
Okay, hang on. I just read, you'll love this, okay?
Huh?
The solicitation rule only precludes solicitation of employment where there is not a prior close relationship between the person and the lawyer, including professional or family. But here's the other thing, it has to be done for pecuniary gain. So when the lawyer for the company solicits representation of a witness, is the lawyer doing it? This is really aimed at the lawyer's pecuniary gain. Do you know what I mean?
Yeah, certainly the company's pecuniary gain, because this person this is how you're going to defend us, right?
This
so
is
therefore,
aimed at
there's no adverse judgment against that.
It's that the rule isn't written with this notion in mind,
It is not.
but the lawyer is going to make some money off it.
And it's an insurer doing it. Let's not forget sight of that.
What's it?
It's an insurer that is doing it.
Right.
It's like here, and I'll call it for what it is. Currently in the medical malpractice arena, ISME, the Illinois State Medical Interinsurance Exchange, many of you are listening on the web, thank you very much. If I subpoena a doctor for a deposition who happens to be an ISME insured right now, guess what? We go to a deposition and there's an ISME paid lawyer there. Is that proper? I don't know. Maybe we'll talk about that someday.
Right.
After we talk about hypothetical number 9. Here we go. We're going to change now, get a little divorce action going here, a little family law. Miles, Mr. Berman's here. We got a little family law stuff going on. All right. You represent a wife in a divorce action where the wife claims that her husband is physically abusive. The husband maintains that the wife is an alcoholic and that she is the one who is violent, particularly towards the children. During her deposition, the wife is asked to explain an injury that their daughter suffered a couple of weeks ago while the wife and children vacationed with the wife's sisters and their families. She answers that the daughter was roughhousing with an older cousin. Last week, the wife complained to you that the vacation had been burdensome since none of the older cousins had come, and daughter complained incessantly about being bored. Must you do anything about the wife's deposition testimony? I take it from the hypothetical that we're assuming that the wife now, in essence, is acknowledging that the child was injured because of the wife, as distinguished from horsing around with the older cousin who wasn't even there. So must you do anything about the wife's testimony that you've now learned might be false? You go back to that false thing again. Professor, what are you thinking?
Well, it used to be the rule that you didn't have an obligation to take so-called remedial measures when a client or a maligned witness testified falsely at a deposition until the deposition was offered into evidence. The comment to the model rule now says no, your obligation is triggered by the false testimony at the deposition. And my guess is for every bit of perjury committed at trial, there are 20 instances of perjury at depositions. It's just more informal. There are more of them. People are witnesses are less careful about their testimony. So the question is, do you have an obligation to take remedial measures to correct this? So first step is the level of inquiry. Do you have to inquire about it? You came to know the falseness after the deposition,
No, before.
Was it last week?
The wife told you that before the deposition. This is happening during the deposition. So think about it that way. The wife told you this before.
Well, then I totally confused everybody. So
I know. I'm sorry. It wasn't clear. It wasn't clear.
But the answer is the same, I think.
It
doesn't
is.
matter when you learn it, whether you knew it at the dep or you learn it afterwards that the deposition is false. Testimony is false. The same obligation and the same analysis takes place for deposition testimony as trial testimony. So when you ask yourself after the fact, do I know that testimony is false? The tough question is how much inquiry and how willing are you to allow the client to give an implausible rationalization of the false testimony? That's the issue we were talking about before. At what point do you say, well, you're my client, I want to believe you, it's good enough for me, if you give some kind of explanation? Oh, it wasn't at the vacation that she was roughhousing, it was just afterwards, I made a mistake. But that part of it, but it's mainly true. So that's the issue here, I think. It's you do have to conduct some inquiry, and if you come to know that the deposition testimony was false, you must take remedial action. You can do that a number of ways, of course. If the dep hasn't been signed and corrected yet, that could be an opportunity to do it then. Otherwise, you're going to have to inform your opposing counsel that that testimony was wrong. You don't want to say was intentionally false, but she was wrong about that testimony.
She was mistaken because of the alcoholism or what?
Whatever.
You don't have to explain that in great detail. I don't think.
Right.
Okay. Mary, you're going to say something?
And I think that one of the things, I've seen a lot of lawyers do it. It can be the best thing to stop the dep right then, as soon as they say it, and ask for a break. And then you have a conversation with your client, because they'll dig in. I mean, once you start down a path, it could get worse and worse and worse. So, and I think the other thing I'd like to echo is that the rules that require us to do something about false evidence, whether at deps or at trial, they don't require us to dish up our clients. We just have to fix it. You know? So that doesn't mean you fully disclose everything wrong that your client did. You do everything you can to correct the falsity without dishing up your
let's because Judge, I was going to turn to you on this one. A related question, Mary. You just mentioned something that's been a pet peeve of mine. Witness is at a dep. Witness is on the stand. Take your pick. But it's a witness, not a client. And something's going wrong. Either the witness is getting it wrong, or the witness is confused, or something. Am I entitled, as in the dep or at trial, to say, time out, need a recess, and I want to talk to the witness? If the judge says, why do you need a recess? You got to go to the bathroom, you got to do what? Now I want to talk to Charlie. Can I do that, Judge?
It's my understanding you shouldn't talk to a witness once they've started testifying until they're finished testifying. The attorney should not talk to the witness, even if it's overnight or something else, another period of time. So certainly you couldn't take a break to talk to them if you're not supposed to be talking to them.
Are you talking about trial or dep or both now?
Well, now I'm talking about a trial.
Right.
Oh, at a dep, I think you can do whatever you can get away with. I guess
some places around the country, the same rule applies at a dep. That hasn't shown up here yet.
So now here's my question that I want to. My twist is now it's my client. My client who has a constitutional right to my counsel and a due process right to my counsel, and Judge Griffin says when we adjourn for the night at 4:30, and he says, "All right, don't talk to your client tonight." I don't think that's right.
It's tricky. And what I typically say, and I say to the attorneys, you should not talk to them about the testimony that they still are going to give. But they're your client. You have to talk to them about other witnesses, scheduling. I mean, to say you can't talk to your client in the middle of a trial, in my mind, is...
There are some folks over there who want to do that. Over in the Daily Center.
Yeah, well, they're probably right and I'm wrong. But to me, it just makes common sense is you have to be able to, and you know, when you're trying cases, you're working all night on them and things come up and you have to be able to communicate with your client as part of your preparation of the trial. But I still don't think you should be talking to them about their testimony.
So you have this obligation to take remedial actions when your client has testified falsely, even if inadvertently falsely. Does that mean you have to wait until the end of the testimony before you have that conversation?
That's what a listener here is asking. When can you check in with a client during a deposition? At a break? When is it coaching?
Yeah. It's easy at a dep, but at least here. But at a trial, you have this obligation to correct the false testimony of your client.
Yeah. And I think the lawyer, at least from my perspective, the lawyer, she's in charge of what's going on in that proceeding to protect her client, and she has that duty to protect her client. Judge?
Well, and Rule 3.3 says the advocate's, if you know they say something's false, the advocate's proper course is to remonstrate
with the client.
Yeah, but I don't even know what that means, so I looked it up. But I guess it's like object or protest or something. But anyway, to remonstrate with the client confidentially. Advise the client of the lawyer's duty of candor to the tribunal, meaning I might tell on you if you don't straighten us out, and seek the client's cooperation with respect to the withdrawal or correction of the false statements or evidence. If that fails, the advocate must take further remedial action, which you can talk about more, because then it really gets dicey with the attorney-client privilege or withdrawing, et cetera, and a lot depends on the facts of when the case or the status of the case, if it's a trial. But, the reality is when you remonstrate with your client, a lot of times you're saying to them, this is not going to go well. This is not just, I'm having trouble understanding how we can make this argument in a way that we're going to be able to convince anybody. So explain to me what's going on here. And I think sometimes it sorts itself out. But I think it's important that you remonstrate with your client confidentially.
All right, well, let's remonstrate with the next two hypotheticals because we're coming to a close soon. Hypothetical number 10. You represent a client who is the defendant in a criminal case in which he is alleged to have sexually molested minors. A civil suit for damages against your client has also been filed on behalf of the minors, and you represent your client in that matter as well. Your client would like to pursue a potential resolution of both the criminal and civil cases, and it is your opinion that it would be detrimental to his interest to settle either case while leaving the other unsettled. You want to approach both the prosecutor in the criminal case and the attorney representing the minors in the civil case with the following proposition. Your client will offer a certain sum to settle the civil case, but the offer of settlement would be contingent upon the criminal case being resolved by agreement that a stipulated bench trial will be held, the defendant will be found guilty on certain lesser offenses, and will be sentenced to the minimum term permitted by statute. Can you make that offer? Isn't that happening every day at 26 in California? What do you think there, Your Honor? Or Professor? Mary, you wrote this one. What do you...
No. I get asked this a lot, and I've actually written several opinions for people.
Well, tell us what the opinion is here.
The opinion is that this can be done if it's done carefully. You are prohibited from doing something that's intended to influence a witness's testimony or cooperation. It would be obstruction of justice if you do something that's intended to keep a witness from cooperating with the prosecutors. But if you're very careful, and I always say put the disclaimers in writing, all I want to do, we would like to settle both of these cases. We have absolutely no intentions of trying to impact the substance of anyone's testimony or their willingness to cooperate. But you're absolutely right, Bob. I mean, and the fact is, a lot of criminal prosecutors in certain kinds of cases would be amenable to a resolution if the victims are amenable.
I think that it's the participation of the prosecutor that makes this doable, because you're not just pitching a sum of money to the complaining witness in order to resolve, to convince her not to cooperate with the criminal prosecution. You're saying, let's all do this. So you're addressing the prosecutor on one side and the civil plaintiff on the other. So it made me nervous, but I think it's okay.
But isn't there a part of this that the judge would have to want to be willing to go along? I mean, right. You're being told, Your Honor, that the deal is that you can only find this guy guilty of the lesser offenses and sentence them to a minimum term permitted by statute. They're kind of preempting your discretion, aren't they?
Yeah, again, I don't do criminal law, but certainly a judge always has the option of rejecting any plea deal anyway. So that's what this is from the criminal court perspective is a plea deal, and I'm assuming that this minor is A, represented by an attorney in the civil matter, and then B, I'm not even so sure if you have to open up some sort of a minor's estate for it, and you might have other judicial approval you might need. So I think that just goes with
For those of you who don't know Chicago law, I mean, this is what got Al Capone jammed up. Al Capone made a deal that with the prosecutors, the judge wouldn't accept the deal. They kind of reneged on the deal, and Al he was going to get a slap on the wrist for his tax fines, and instead got 11 years in the pokey, and that's what happened to Al. And he is on trial on April 11th. Here in Chicago, the trial of Al Capone for the murders. He have never charged murders of the St. Valentine's Day massacre, God bless you, at the Goodman Theater, sponsored by the ABA section of litigation. I am playing Al Capone.
That's typecasting.
Very convincing.
Deborah on the internet is asking, isn't that what happened with Hastert?
What's that?
Deborah on the internet is asking, isn't this what happened with Hastert?
Yeah, sure.
Not that we know of, but it might be.
I was wondering.
It might be. Right.
Might have been. Right.
All right. Number 11 here is you represent a young man who is charged with various felonies, including armed robbery, armed violence, aggravated battery on a police officer, and resisting arrest. Your client was shot by police during the arrest and has filed a lawsuit against the arresting officers and the police department. It's kind of like taken out of the headlines. In response to your discovery request in the criminal case, the state has given you copies of several police reports as well as medical records concerning treatment of injuries to the arresting officers. The medical records include an observation by a treating physician that the officer's injuries do not appear to be aligned with his description of how they were inflicted. The case has caught the attention of the news media, and you are convinced that the prosecutor or police are feeding reporters information suggesting that your client has a substantial arrest record and is affiliated with a gang. The police reports were given in discovery contradict information being reported. You believe that the stories are swaying the jury pool against your client, but your motion for a change of venue or delay of the trial is denied. You are convinced that you could turn the tide if the media got a hold of the medical reports and started to focus on wrongful conduct by the police. Distributing the police reports would also help. Is there an ethical way to get these reports into the hands of the reporters? Mary, doesn't HIPAA prevent the disclosure of these medical reports?
I'm trying to remember who's the victim. The police officer.
The police officer.
I don't know. I mean, I assume that the defense attorney only has them because they were disclosed pursuant, with an appropriate HIPAA release. I was just going to give
right. And so we skip over that one. But what about the trial publicity issue here? I want the state's attorney's office or the U.S. attorney's office is, feeding information to the Trib and the Sun-Times and Fox News, and my guy's getting hammered, and I want to feed the reporter. I got a friendly reporter on the other side, and I want to feed him a little information. Can I do that on the QT and feed him?
Interesting. I mean, the rule generically tells us that we cannot make public statements that we understand would be disseminated where that would present a serious and imminent threat to the fairness of an adjudicative proceeding. And that's important because, for the most part, the rule is enforced in the context of statements made in advance of a jury trial. It tends to be. There's a litany, and I think it's 3.6c, that tells us the things, or B, that tells us the things we can say. And this was written by the prosecutors, all the things that they want to be able to say. And it's okay. You know what I mean? These are considered neutrals. They get to say these. But the allegations or the leaking of information about an arrest record or suggestions that somebody's affiliated with a gang, those don't fit into the okay things. So, but what we don't know is, did the prosecutor make those? And I'm just going to add this because there's a special rule for prosecutors that I didn't include in this, Rule 3.8, that puts a prosecutor in the position of keeping the police in line or other people that are assisting in a prosecution on this rule. And it's the prosecutor's duty to assure that these other people assisting in the prosecution don't make statements that or leaks that the lawyer himself couldn't make.
Well, let's talk about this a little bit in the civil context, because in the absence of two things, different questions. One is, I now file a heater civil case, and I go before the judge, and she says, hey, I've seen and I've read about your cases in the newspaper. I don't want to be reading about this case in the newspaper. I'm ordering all the lawyers here not to talk to the media at all. Does that judge have the power to do that? Does that interfere with my First Amendment rights or my client's First Amendment rights as her spokesperson? Ooh.
Well, the standard will be the same, and that's the constitutional question, not the ethical issue here. But you would have to attempt to quash that order, perhaps in interlocutory appeal, saying that the extent of the gag order is not narrowly tailored to protect the jury trial that's going to come up. So that would be the standard there. Those orders are enforceable, but they have to be narrowly tailored. And those same reporters that have been calling me and asking me to give an interview said, by the way, we know you took the deposition of the CEO of ABC Corporation, and that we want to know what that person had to say in that deposition. Can you give us a copy of the disc, the digital disc of the deposition? Can I just give it to the reporter from ABC? Well, I mean, it's a public record, but the question... It's not a public... No. This is a deposition that's taken... It's a public lawsuit, right? But the deposition itself was taken in my office, in Mary's office, and it's a witness... No, are you assuming the gag order or without the gag order? No gag order. No gag order at this point. I don't see any prohibition on the same standard applies. So you've got the question is whether or not you come under any of the categories in 3.6b for revealing that information, and if there's going to be a jury trial, whether that could in effect taint the jury. And it's deposition of a party opponent. That information is going to be admissible at trial. I think it's harder with these police reports maybe because they may not be admissible at trial. So something that's going to be admissible at trial is something the jury is going to see anyway, deposition of a party opponent. It's hard to see why that would be... So the broader question that I get to is that when Mr. Bierman takes the deposition of the wife in that case, and there's no protection order, and there's nothing preventing, and he gets a call from the newspaper. He's got this high-profile wife of a billionaire trader in Chicago, a fund manager, and the New York Times wants a copy of her deposition. Can he give them that copy of the deposition, assuming there's no protective order or agreement between the parties? He won't. I know he won't.
Assuming there's no protective order,
okay.
I think, yes.
There's a big exception to 3.6 we haven't talked about. Is that if information is leaked by somebody else, it doesn't have to be the prosecutor, it can be anybody else. Right. You can act to defend your client by revealing what's tailored to basically balance the misrepresentation.
Right, and in this case, the hypo tells us that the police reports would balance the arrest and gang affiliation allegations.
We have time for one question from the web.
Bill is saying, aside from the ethical issues, isn't there a risk of exposure to a defamation claim since the litigation privilege doesn't apply?
Yes.
It could be.
Yeah, you have to watch out what you say.
You're jumping out of your seat to ask one more question. Yes, sir.
Well, I think this scenario goes beyond the niceties of legal ethics and all that, and goes to fundamentally what's right in the society. When you say, well, there are rules that say you can't really reveal when a cop, for example, is acting in a sense...
There's a question here, right?
A danger. Well, I'm going to say, am I not right and saying that the fundamental issues go beyond the rules of ethics when you have things like Sandra Bland being killed in Texas, you have the guy who was Luan McDonald who was shot 16 times. Whatever information reflects upon the truth in an open society of how the state treats its citizens has to come out, period.
There we go. On that note, folks, I want to thank our wonderful panel, Professor Burns, Mary Robinson, Judge Griffin. Thanks to everyone in attendance. Thanks to everyone online. See you next year for the 10th in a series of programs on ethics in the law. And thank you.
Thank you for attending. And please, if you're in the DePaul seminar office here, collect your CLE certificates as you walk out the door. For those of you on the web, you'll be receiving your certificate online to the email address that you registered at within a week. Thank you on behalf of all of us at Clifford Law Offices. We appreciate your attending. Good night.